Hello everyone, my name is Geetanjali Sharma. I am a graduate of Cambridge University, having specialized in international economic laws and dispute settlement. I am here before you to present the module on General Agreement on Trade in Services. To begin with, I will first provide a brief overview of the module. First, we shall be discussing the main differences between the General Agreement on Trade in Goods, which is the GATT agreement, and the Agreement on Trade in Services, which is the GATS. Thereafter, I shall be providing a brief overview of the GATS agreement, and we shall also look into the application and scope of GATS. We shall be looking into the legal and technical meaning of terms such as services, measures by the members, affecting, and trade in services. We shall then look into the various obligations that are imposed by GATS upon members, including the market access obligation, the national treatment obligation, the manner in which the schedule of commitments is drawn and its impact thereon, and various unconditional obligations. We shall also be touching upon issues such as the exceptions provided under the GATS and other provisions under the GATS, including the Economic Integration Clause. To begin with, as a brief introduction to GATS, one must understand the complexities that were involved in the negotiation of the GATS process. The reason for the complexity is the basic difference between GATT and GATS. Now, unlike trade in goods, which is characterized by coverage of mainly goods, trade in services covers cross-border exchange of services, including consumer movements, factor flows, movement of investment, and most importantly, labor. Therefore, to accommodate the extensive coverage of GATS and the requirements for member countries to make policy and structural changes to open up such a sector for international trade, member countries had several issues on deciding upon various flexibilities that were being offered under the GATS. For example, unlike the GATT, there does not exist a wholesale ban on using a quantitative restriction under the GATS. This is a kind of flexibility or policy space agenda that countries negotiated for while they were drawing up the GATS agreement. Similarly, GATS also is characterized by the concept of built-in agenda. Member countries in 1994 were well aware that opening up of services sector would be a highly challenging task, and trade in services would not be that easy as trade in goods, anyway had a history of 50 years of its origin, whereas trade in services, as was being negotiated in 1994, was a fairly new concept. Therefore, members agreed that liberalization in services would be in a phased manner, providing several flexibilities and policy leeway to the members, and liberalization would only happen in various sectors as and when countries would be allowed and willing to open up those sectors. Therefore, this process of constant and ongoing liberalization which member countries agreed upon is known as a built-in agenda of GATS. Now, having discussed this brief overview, let us look into the basic differences between the liberalization of trade in goods vis-a-vis its liberalization in services. There is a vast scope and coverage of GATS as it covers across border trade and also trade across various sectors and industries. Now, flexibilities that are given to the member countries to liberalize their trade and services are therefore in proportion to the challenges that are involved in the opening up of services. Under GATS, members have even been given flexibilities with respect to core principles of trade liberalization, for example, the national treatment and the most favored nation clause. Unlike the NT and the MFN treatment in the GATT provision, in the GATT agreement, which are highly sacred and no deviation is permitted. In GATS, members have been given the opportunity to restrict the application of national treatment under GATS, and they've also been allowed to seek exemption from application of certain MFN obligations. And therefore, owing to the nature and differences between trade in goods and trade in services and the greater demand for a policy space in the services segment, we've seen that liberalization between trade in goods and trade in services have differed, even at the cost of compromising some of the basic tenets of international trade, which is national treatment and most favored nation. Now, we shall move into the various aspects of the GATS framework and its application to members. The graphical picture shows that GATS has two methods of its application. Now, first, the text of the GATS, which is the framework, and the annexes are applicable on all members. However, the schedule of commitments of GATS, which is, as I will explain later, an integral part of the GATS agreement, along with the MFN exemptions, are applied individually to members and do not apply across board to all members at a given point in time. Therefore, for schedules of specific commitment and MFN exemptions, members have to make a special request, and based on that or based on a negotiated agreement to open up a particular sector, those provisions become obligatory for the members. Now, we shall look into the nature and scope of GATS and the meaning of trade in services. Now, here the analysis of Article 1.1 of GATS becomes important, as 1.1 of the text of GATS agreement states that GATS applies to measures by members affecting trade in services. Now, this definition has been divided into 4 parts, and the understanding of each of these 4 elements of GATS becomes very relevant. First, we look into the meaning of the term services. Second, measures by members. Third, the nature and scope of the word affecting. And last, the meaning of trade and services. Now, with respect to the meaning of services, the GATS does not define what services are per se. However, there is a heavy reliance that is placed upon the services sectoral classification list, which has been developed during the Uruguay round of negotiations, largely based on the United Nations Central Product Classification System. This list has been used as a supplementary means of interpretation under Article 32 of the Vienna Convention on Law of Treaties in order to conclude several meanings and interpretations of the term services as they have arisen before the panels and appellate body. For example, in the case of US gambling, the meaning of the term other recreational services except sporting in the US schedule was interpreted as including gambling and betting services, placing reliance on the principles of treaty interpretation as flowing from the United Nations Central Product Classification System, where US had made a similar commitment and a similar description of the services. Therefore, even though services are not defined in the GATS framework, other forms of annexures become very relevant, and the same have been affirmed by panels and appellate body as they have proven as useful tools of interpreting the term services. Second, we move on to discuss the meaning of measures by members. Now, GATS extends to measures by all levels of the government. It also includes measures by non-governmental bodies that are acting with delegated powers of the government. However, one must note that GATS does not apply to purely private measures, and the meaning and the definition largely revolves around governmental actions or government delegated actions. Now, the third aspect of the definition under GATS 1.1 is the meaning of the term affecting. Now, the term affecting has been given a wide interpretation. As was demonstrated by the appellate body in the EC Bananas case, it was clarified that the term affecting is interpreted to include a broad scope of application, and its meaning is wider than the term either regulating or governing. Therefore, giving a wide definition to the term affecting, one can say that a large part of actions of the government or potential actions by delegated authorities can come within the purview and operation of GATS, as conduct which does not pertain to only regulation or governance may also be said to affect trade and services in some way, leading to the application of GATS. Now, we discussed the last aspect of services definition, which is the meaning of trade in services. The meaning of trade and services is linked to understanding various modes of supply. These modes of supply are primarily four in nature, as have been defined and discussed within the GATS framework, and they include cross-border supply, consumption abroad, commercial presence, and presence of natural persons. We first discussed the meaning of cross-border supply. Under mode 1, which is the cross-border supply, a service is transacted across a border without either the product or the consumer moving. The service supplier therefore is not present within the territory of the member where the service is being supplied. Examples of cross-border supply include distance learning, e-banking, telemedicine, etc. The second mode of trade and services, as discussed in the GATS, is consumption abroad. This mode of supply is often referred to as the movement of the consumer. Now, the service consumer crosses the border to where the supplier is located in order to obtain the services. Now, examples of consumption abroad include holidays abroad, attaining foreign education, and overseas health care. Now, discussing the third aspect of trade and services, which is one of the most vital manners in which service is transacted, is through commercial presence. Under this mode, the service supplier establishes a commercial presence through a foreign-owned affiliate, subsidiary, or representative or branch office in the country where the consumer is located. Now, examples of commercial presence include establishment of branches or subsidiaries of foreign banks, setting up of a subsidiary company engaged, say, in telecommunication services or consultancy services. Last, and the most vital mode of GATS, which also makes GATS very controversial, is through the presence of natural persons. This mode covers natural persons who are themselves service suppliers, as well as natural persons who are employees of foreign service suppliers in the host country. In schedules, members have taken commitments based on the following categories of persons. Therefore, these categories of persons are examples of the fourth mode of supply. These include independent professionals, intra-corporate transferees, business visitors, and contractual service suppliers. As stated in the initial part of my presentation, this fourth mode becomes highly controversial owing to the opening up of services sector with respect to labor and natural persons. Therefore, the discourse of GATS inevitably gets interlinked to immigration laws and laws pertaining to the movement of natural persons, as all of this is premised from the fourth mode of supply under GATS. Now, having discussed the various contours of the meaning and nature of trade in services, we now move on to discuss the substantive obligations under GATS. The first substantive obligation is the unconditional obligation, which is in the nature of most favored nation clause. Second is the conditional obligation to include market access, which is defined under Article 16, and national treatment, which is defined in Article 17. These obligations apply on specific commitments that members have undertaken in their schedule of commitment, which are annexed to GATS, pursuant to which members are allowed to maintain restrictions on trade and services. Therefore, as discussed before, the concept of national treatment under GATS is a conditional obligation and not an unconditional obligation as is present in, say, the agreement on trade in goods. Now, we discuss each of these obligations in a bit more detailed manner. First, we look into the market access obligation, which is defined in Article 16 of GATS. Article 16 of the GATS provides an exhaustive list of areas where market access obligations must be maintained by members and restrictions should not be imposed in that regard. Now, the 6 areas of this exhaustive list includes the number of service suppliers, the value of service transaction or the assets, the number of operations or quantity of output, the number of natural persons supplying a service, the type of legal entity or a joint venture, and the participation of foreign capital. The issue of market access obligation has been discussed in several case laws by both panel and appellate body that have arisen in various disputes. I would just briefly mention the definition of market access obligation and its scope as was discussed in the most famous US gambling decision. In the US gambling decision, an issue arose as to whether a complete ban would amount to a violation of market access obligation, and does a complete ban affect the numerical value of any service being supplied. It was the argument of the United States that since the measure is in the nature of a ban, it does not hold any numerical value and therefore it cannot be said to violate the terms of Article 16 of the GATS. However, the appellate body and the panels both were innovative to evolve this concept that a ban, which is a complete ban, is in the nature of a zero quota, which tends to attract the numerical value which is mentioned in Article 16 of the GATS, and therefore a ban being in the nature of a zero quota would stand being in violation to Article 16 of the GATS framework. Now we move on to the second substantive obligation, which is the national treatment obligation under Article 17 of the GATS. Now the benchmark of national treatment is not whether there has been a formally identical or different treatment of domestic and foreign services and service suppliers, but if the conditions of competition have been modified as a result of the measure. Therefore, the question is not with respect to providing differential services, but by altering the condition of competition that may affect services in some manner or the other. This is the sort of definition of discrimination in the context of national treatment of GATS, which also captures both de facto and de jure forms of discrimination. Further, the standard of national treatment obligation under Article 17 of GATS is linked to the discourse of national treatment under the GATT, where the term no less favorable has received tremendous interpretation across panels and appellate body. The meaning of the term discrimination and also no less favorable treatment becomes relevant even in the GATS context, as panels and appellate body in deciding cases of national treatment violation in GATS have made several references to the GATT jurisprudence on no less favorable treatment. Having discussed the two broad obligations in the form of national treatment and market access, now we move on to understand the concept of GATT's schedule of commitments and how national treatment and market access obligations are conditional upon the manner in which members make these schedules of commitment and are made responsible for the commitments they have made therein. To begin with, the process of scheduling is done by member states. The choice of sectors as to where members wish to commit and the extent of coverage they wish to provide is for the discretion of members. Have to take decisions whether and what limitations, if any, they wish to maintain with respect to market access, Article 16 of GATS, and what limitations, if any, they wish to maintain on national treatment, which is Article 17 of GATS. Further on, members may also make additional commitments relating to measures affecting trade and services which are not subject to scheduling either under Article 16 or 17 of the GATS, and if they wish to undertake any further obligation under Article 18 of the GATS. Having discussed the broad nature in which a scheduling happens, I am now presenting a graphical picture of what comprises of a schedule of commitments under GATS. This is a typical schedule or a table which has on one hand various modes of supplies, also deciding upon various sectors and the various obligations that are imposed. Therefore, a table will comprise of various modes of supplies, various conditional and unconditional obligations, and also the various sectors in which they are playing. In the course of this presentation and during a discussion of the scheduling process, we will also understand concepts such as a positive list approach under GATS, the meaning of terms such as none and unbound, and what additional commitments members may undertake. Now, if we look back at the graphical schedule that has been presented, we see that the first column is used to indicate the sectors covered. Now, GATS does not prescribe any particular sector focus, and it is for each member individually to decide on its discretion as to which sector it wants or does not want to include within its schedule. Now, the scheduling method used by GATS is often called a bottom-up or a positive list approach, since market access and national treatment commitments are undertaken only for sectors that have been included in the list and not for the ones that do not find a place in the list. Further, sectors that are not included in the schedule are automatically considered outside the scope of market access or national treatment obligations. For unscheduled sectors, as I have discussed before, only unconditional obligations apply, which also include in particular the most favored nation treatment principle and certain transparency related obligations. The positive list approach thus allows member countries to customize their commitments according to which national policy choices are made, taking into account the various constraints in liberalization of services. Therefore, this scheme of things in providing the flexibility of a choice of sector along with the scope of making a particular obligation conditional upon itself is a breakthrough provision as compared to its counterpart in GATT, where these provisions are said to mandatorily apply upon the members. Now, moving on to the second and third columns as have been described in the pictorial graph. The second and third columns are used to specify the market access and the national treatment conditions for each of the mode of supply. This is done by listing relevant limitations to the requirements specified in Article 16 and 17. Now, the choices which are given to the members may take shape in the following manners. First, members may liberalize access by taking bindings that require it to lower its applied regime. Second, it may maintain the status quo by binding the applied services regime, or it may also take bindings that are more restrictive than those measures that are currently in force. Therefore, a linkage between the commitments that they've made in the schedule and the manner in which they are actually put into application is also governed to a large extent by the choices which are provided to member states. Any additional commitments that do not fall under the market access and the national treatment provisions of the agreement are undertaken in the fourth column. So these additional commitments often relate to the adherence by the government to certain regulatory standards or competition related disciplines. Therefore, so far we have discussed the nature of a typical GATS schedule and the meaning of each of the four columns as present in the schedule. Now we move on to discuss the unconditional obligations under GATS and how it applies to member states. The MFN, or the most favoured nation requirement, is present in Article 2 of the GATS. It is in the nature of an unconditional obligation and it applies to any measure that affects trade in services in any sector falling under the agreement, irrespective of whether specific commitments have been taken or not. For instance, a member may have chosen not to commit its private education sector since it wishes to keep that sector closed to foreign services and service suppliers. Here we also discuss the relevant case law, which is the US gambling issue and how it related to certain provisions of GATS. The US gambling decision involved a ban on online gambling sites in the US by way of certain regulations which mainly targeted countries such as Antigua and Barbuda, who were the chief exporters of these services. The United States tried to defend this ban on account of public morals exception, as the addictive nature of gambling affected the social fabric of the society. The appellate body in this case, by upholding the panel's finding, held that the US measure was designed to protect public morals and maintain public order within the meaning of Article 14A of the GATS, which deals with the exception clause. Therefore, the exception clause under GATS, as has been described in the US gambling decision, threw some light on the nature and meaning of public morals or public order as has been described in GATS. Inevitably, the meaning of public morals as has been discussed in the GATS jurisprudence also found discussion in the appellate body's analysis, which further indicates that GATS jurisprudence are being relied upon by GATS panel and appellate body reports, also holding that public order and the meaning of the exception under 14A is slightly broader than the one in GATT, and therefore this provision could very well fit within the purview of Article 14A. The appellate body thereafter reversed panel's decision and also held that the United States has been able to make a prima facie case of necessity, as Antigua has failed to identify any other alternative measure that may be reasonably available. However, the ban on the whole did not sustain, as the appellate body held that the measure did not meet the requirements of the chapeau under Article 14, as the United States was found to discriminate in the enforcement of these measures. Therefore, this provision becomes relevant and the provision and the case law becomes relevant in understanding the interpretation provided by the panels and appellate body to Article 14 of GATS in the light of the jurisprudence of GATT under the exceptions clause. Now, we come to the last part of our presentation and discuss a few other provisions under the GATS framework. GATS, apart from the national treatment, most favoured nation and market access obligations, which are its core foundational obligations, also has certain aspects on the economic integration, which is defined in Article 5, the domestic regulation, which is defined in Article 6, and the concept of recognition, which is defined in Article 7. Apart from this, there are several annexures which also become relevant and have arisen as topics of controversial disputes before the GATS panel and appellate body. Due to paucity of time, we shall not enter into each of these obligations, but only discuss the obligation on economic integration. Now, economic integration provides room for economic integration agreements outside the framework of GATS, allowing members to further liberalize in services. By insisting that a substantial sectoral coverage and substantially all discrimination is removed, GATS essentially is indicating, somewhat on the similar lines of GATT Article 24, that discriminatory agreements will only be permitted if they contribute to further lowering of trade barriers and make a substantial contribution to the integration of overall services economies. At the same time, the overall level of barriers in services must not be raised vis-a-vis the non-participants in the services covered, and should an agreement lead to the withdrawal of commitments, appropriate compensation must be negotiated wherever members are affected. Therefore, Article 5 of GATS provides for economic integration, and the jurisprudential value of GATT Article 24 dealing with regional trade agreements also become relevant in this regard. Having discussed this, I will now summarize the key aspects of my presentation. In the module on GATS, we have first discussed the main differences between the trade in goods and trade in services, and the method in which the liberalization of the two agreements differ, leading to several policy choices and respect for flexibilities that have been provided to members. In this context, we have discussed the definition of a positive list approach and the concept of built-in agenda of GATS. Thereafter, we have discussed the various methods in which one can define trade in services, including the four modes of supply and the scope and nature of the meaning of the term services. We have also looked into the conditional and unconditional obligations provided within the GATS framework and discussed its operation with respect to the schedule of commitments, which demarcate the extent to which the conditional obligations apply on the members. We have discussed the various methods in which one can define and interpret a particular schedule or table under the GATS framework, along with which we have also highlighted upon other obligations of GATS, including economic integration clauses and exception provisions under the GATS framework. Thank you.